Hello, everybody. It's good to be back with you. It's the 16th of September, and believe it or not, we are just a few days away from fall. Probably many of you believe it because it has felt in lots of ways already like fall with routines picking back up and all the rest of the divider line activities as between summer and fall. We, of course, have continued to stay on top of, and we've continued to track the important issues that we believe matter to all of you. And so we want to walk through what we think will be a useful agenda and content to follow. So if Kathy, if you could go to the next slide, please, I'll take that moment on the agenda right now. After I conclude here, Caroline Westover from our Syracuse office, who's spoken a number of times before to this audience concerning immigration policy that is pertinent to employers, asked to come on because there are updates that she felt were important enough for all of you to know as you kind of absorb the news. Obviously, every day there feels like there's something different. What we've been trying to do is to make sense of it all, and Caroline in particular and other colleagues of hers in the immigration practice are very focused on all that. And so Caroline's going to let us know what we really need to know now. After that, Patrick Caldarelli, who sits around actually adjacent to me here in New York City, once sat around the corner, now sits much closer to me even. He's on the webinar to discuss a package of bills concerning worker and labor protections, presumably anyway, that the governor signed. Some of that will be in the eyes of who it is that's interpreting what it is the governor signed, and Patrick's going to walk through that all. Alyssa Christian is back, also from Syracuse. Alyssa is our regular correspondent, as it were, on non-competes, and there has been some further activity in the space that Alyssa will catch us up on. I will spend a moment talking about cybersecurity regulations in New York State specific to hospitals that are about to become enforceable. I've spoken about them before, but it's really a reminder and an update on where things stand. But with that background provided, let's move right to Caroline, who will be our first speaker. And we're delighted that Caroline can be with us. And I will come back on as soon as Caroline concludes her remarks. Caroline, the floor is yours, and thank you as always.
Good afternoon, Gabe. Thank you for including me today, and it's nice to be with everyone this afternoon. We've got five brief topics that I'm gonna touch upon this afternoon. Kathy, can you put up this slide? Perfect. So here's our very brief agenda for the next 10 minutes. With that, I'll just dive right in. Our first update pertains to new guidance issued by the U.S. Department of State regarding non-immigrant visa processing. This is relevant to many of our clients because you may have foreign workers who come to the United States to work. In order for them to physically be admitted or enter the United States, they typically need a visa. And so they will go to the U.S. consulate in their country, in their home country, usually get an appropriate travel visa in their passport, and then physically enter the United States. Well, on September 6th, the U.S. Department of State updated its instructions for individuals trying to schedule non-immigrant visas and non-immigrant visa appointments at U.S. consulates and embassies abroad. This can include things like business and exchange visitor visas, student visas, worker visas, etc. This guidance does not necessarily apply to certain diplomatic workers or government workers or other what they call official type visas. And there can also be exceptions in this updated guidance for individuals seeking humanitarian parole or admission into the U.S. for medical emergencies. But the guidance from the Department of State now says that applicants should, emphasis there on should, schedule their visa interview appointments at U.S. consulates or embassies in their country of nationality or residence. Typically what this means is applicants, for example, if I'm an Indian national, I'm encouraged to schedule my visa appointment at a U.S. consulate or embassy in India. Sometimes people, when they come to the United States, say, well, Canada may be closer. Even though I'm not from Canada, let me see if I can go there to process. This current guidance now is encouraging people, or I should say discouraging that prior practice, if you will, and saying that applicants should be prepared to demonstrate residence in the country where they are applying. And so that could be another basis of the interview, that they show that they have some connection to the country where they are seeking their travel visa. This does mark a change in Department of State practice. And the Department of State has also acknowledged that there may be some countries where the US currently does not have consular operations, either because the consulate is closed or there was never a consulate there to begin with. In those instances, the Department of State has published a designated country that will take individuals from that particular country for visa processing. So employees, employers, individuals seeking a visa to come to the United States would be well served to look at the latest update from the Department of State in that regard. The Department of State has also noted that applicants who do apply for an appointment in a location where they do not have nationality or residence, they may still be permitted to do so. However, the wait times will be significantly longer. And the phrase significantly longer comes directly from the Department of State. So individuals and foreign nationals should plan accordingly. Second update is for temporary protected status for Venezuelans and the potential impact that may have on work authorization. We have received a flurry of questions in the last few weeks about individual workers from Venezuela who may have their work authorization document, also known as an EAD card, that may have had an expiration date of September 10th, 2025. That was primarily a date used for individuals who may have been in the United States under temporary protected status under the 2021 designation for Venezuela. Does this mean that they are no longer authorized to work as of last week? It does not. But what has happened is on September 8th, last Monday, the Department of Homeland Security published a notice in the Federal Register to indicate that it is seeking to terminate the 2021 TPS program for Venezuelans. That termination would take place on November 7th, 2025. So individuals from Venezuela who have an EAD card that has an expiration date of September 10th, 2025, March 10th, 2024, or September 9th of 2022, that work authorization has been given short reprieve and an extension until November 7th, 2025. There's one additional caveat here. The TPS termination, not only for the 2021 Venezuelan designation, but also there is a 2023 Venezuelan designation, have been the subject and will likely be the subject of additional litigation. What does this mean? It means stay tuned. We need to see what continues to play out in the court system to see if that November 7th expiration date may be extended, may be modified. So the takeaway for employers here is take stock, see if you have any employees that may be impacted by some of these changes to TPS from Venezuela. And if you have questions or concerns, probably a good idea to reach out, give us a call before you take any steps to remove somebody from the payroll or something else. So just keep that in mind. Our third update is very quick here. The U.S. is seeking to modernize its payment system. So any employer or individual who is familiar with USCIS and has made a petition or an application for benefits to USCIS knows that frequently that petition or application needs to contain a check or a money order to cover the associated filing fee. So earlier this year, actually late August, USCIS announced that it's changing its payment system for accepting those filing fee checks in an effort to modernize its system, reduce time to process payments, and hopefully minimize any instances of potential fraud. Accordingly, effective as of October 28th, USCIS will no longer accept money orders or good old-fashioned traditional checks to cover those filing fees. Instead, payments can either be made by credit card or by electronic debits, also known as ACH debit transactions. This may be a significant change for some employers who are used to writing their own check, or who may ask their law firm to write the check and simply bill their account. And so we just want to make sure that people are aware of this change, whether you're an individual or an organization. If you are planning on using a credit card to cover these payments, a good rule of thumb is to also make sure that your credit card company is aware that you are making certain payments so that they don't tab those payments as fraudulent charges, and then your case gets rejected. Okay, the fourth update is that the USCIS is expanding its consideration of anti-Semitic, anti-Americanism concepts in requests to any immigration benefits. So in several immigration updates that we've provided throughout 2025, we've mentioned various changes to immigration policies and procedures that have been implemented in response to various executive orders from the Trump administration since 2025. In line with this general pattern, the USCIS has announced, or did announce in mid-August, that it has updated its USCIS policy manual to clarify factors that officers may be able to consider in connection with certain immigration benefit requests. For example, a green card, a work authorization document, where the officer has the ability to exercise discretion. So for example, if a foreign national has a past request for parole, that can be considered. If the individual has involvement in anti-American activity or involvement in a terrorist organization, or where they're adjudicating requests for certain benefits where evidence of anti-Semitic activity is present. USCIS has also expanded, and we talked about this on an earlier episode this year, that when people go to the US consulate, for example, their social media posts, their phones could be vetted, searched, as the government looks for anti-Semitic activity or anti-Americanism activity. This is now extending not just simply to consular processing or border processing, but also to USCIS officers who are looking at cases submitted through that agency. And so this expanded use of social media vetting and reviews for anti-American activities can include, for example, an anti-American activity will be an overwhelmingly negative factor in any discretionary analysis. So what constitutes an anti-Americanism activity? A good question, but right now there's not clear guidance on that. What we do know is that the USCIS has indicated the following, and this is a quote: anything where a foreign national has endorsed, promoted, supported, or otherwise espoused views of a terrorist organization or group, including aliens who support or promote anti-American ideologies or activities, anti-Semitic terrorism or anti-terrorist organizations, or who promote anti-Semitic ideologies. This change from USCIS took effect immediately. One more point in terms of current events, because these issues are changing rapidly. Given the political violence that occurred last week in Utah with a MAGA influencer and the killing of Charlie Kirk, Secretary of State Marco Rubio earlier this week announced that foreign nationals who celebrate the killing of this young man should plan to have their visa revoked. And he also specifically commented as follows: America will not host foreigners who celebrate the death of our fellow citizens. Visa revocations are underway. And if you are here on a visa and cheering on the public assassination of a political figure prepared to be deported, you are not welcome in this country. So a reminder for anybody who is here as a visitor, a student, a worker through the USCIS or the American immigration system, the government is looking to determine whether or not you are eligible to remain here. Finally, this update hits a little bit closer to home for those of us in the central New York region, but earlier this month, on or around September 4th, a business located in Cayuga County, which is in central New York, received an unexpected visit from federal government agencies. Members from ICE and the Custom and Border Protection Group, along with other law enforcement officials, raided a manufacturing facility, presumably looking for a violent criminal or criminals. Estimates suggest that 57 of those workers were taken into custody, and approximately 52 were deported to Guatemala or other locations. 5 individuals out of that raid remain in U.S. custody and will stand trial, presumably, or go through the deportation process. And based on a press conference, the reason why those 5 remain is that they had previously been deported and illegally returned to the U.S. According to the reports and public comments issued by the employer in this particular raid, the company had actually, in fact, complied with its I-9 employment verification requirements and was under the impression that their employees were all authorized to work in the United States. The acting U.S. attorney for the Northern District of New York, which covers 32 counties in Northern New York and Central New York, issued a press conference several days after this enforcement operation and said the following: "The bad old days of turning a blind eye are over. We recognize the contribution of lawful immigrants, but illegal entry after deportation is a flagrant violation of federal law and will not be tolerated. Nor will we tolerate the greed of those employers that knowingly hire illegals." We're reminding clients once again, now would be a good time to review your I-9 compliance to make sure that everything appears in order. Those are my updates, Gabe.
Thank you so much. They were very helpful, and they're the kind of thing that we all should be hearing about. So we appreciate you taking the time to walk the audience through. Let's shift quickly to Patrick with our New York City office. And Patrick is going to spend a few minutes talking about a set of bill signings that the governor announced recently. And we want to just tell you a little bit more about their character grossly and get into some of the particulars. So Patrick's here to do that for us. Patrick, please go right ahead and welcome back.
Thank you, Gabe. Next slide, please, Kathy. Yeah, so these recent bills, they were signed by the governor last week, and they were all effective immediately. And they include a dramatic increase in the Public Employment Relations Board, or PERB's, jurisdiction over private labor disputes, as well as increased worker protections, mostly for state and public employees. So the first bill we're going to be discussing is probably the most impactful. The statute amends Section 715 of the New York Labor Relations Act, and it expands PERB, or the Public Employer Relations Act, jurisdiction over private labor disputes. And it specifically states that PERB does not have authority where the National Labor Relations Board successfully asserts jurisdiction over any employer, employees, trades, or industries pursuant to an order by a federal district court. And this is a bit irregular because typically the board can proceed through its administrative process without judicial intervention. And that if there is judicial intervention, it's typically something like a 10-J injunction, where the district court is actually reviewing a board decision. So this means that PERB, because this is uncommon to have a judicial order, PERB will have the similar authority that the NLRB does, and you'll have overlapping authority, both PERB and the NLRB, and you could have parallel proceedings where an individual or the union files a charge with the NLRB, and they could do the same thing with PERB as well. Additionally, the statute also has provisions regarding existing collective bargaining agreements and the ability of PERB to certify collective bargaining agents. Specifically, PERB is authorized upon application verification to certify the exclusive bargaining representatives of any bargaining unit previously certified by another state or federal agency. So that would include the NLRB there, and that all existing terms and conditions of employment between a certified exclusive bargaining representative and an employer shall remain in full force and effect while that previously mentioned certification process takes place. And it says a constitutional challenge by the General Counsel is likely imminent, but that's actually not true because it just happened yesterday. The NLRB filed a complaint in the Northern District of New York seeking an injunction, arguing that the new statute here is preempted by federal law and is unconstitutional. So the next bill we're going to be discussing, this amends Section 27B of the labor law, and that creates a duty for public employees to have and develop a violence prevention program within the workplace. Specifically, this new bill protects employees from a wage reduction when they participate in the investigation of a violation of this worker protection program to protect employees from violence in the workplace. And specifically, the statute says that no employee who accompanies the commissioner on an inspection, participates in a risk evaluation and determination inspection, or participates in an annual review program shall suffer any reduction in wages. So you can't penalize an employee for participating in an investigation where there's a violation of the workplace violence prevention program. The next statute we'll be discussing, this amends Labor Law Section 22(4)D, and that creates wage requirements for certain renewable energy systems. Here, contractors and subcontractors that are performing construction work for covered renewable energy systems are required to have apprenticeship agreements. Specifically, the statute says that any covered renewable energy system shall require its contractors and subcontractors performing the specified work to use apprenticeship agreements. And essentially, a apprenticeship agreement is a contract between either the employee and the employer, or the employee and the employer association, and an employee association and the employer. And it just sets out the terms and conditions of employment for that the work that's being done by those employees. And next, we have the amendment to the New York Civil Service Law, and that covers suspension and demotions following layoffs. So here we have increased protections for public unions during times of suspension and layoffs. And essentially, this creates a floor for certain protections. Previously, this statute was interpreted as a ceiling, but the legislature went and explicitly indicated that the purpose of the statute is merely to create a floor. So if there are additional benefits and protections contained in a collective bargaining agreement, those protections would apply, and they would not be replaced or limited in any way by this statute. So it's just creating a floor, and if there's any additional protections in a CBA, those would govern, and there's no limitation in this statute. That's it for me. Thank you, Gabe.
And thank you. I really appreciate the time as always. And Patrick, we will absolutely, have you back on as the implementation of these new statutes starts to roll out. And for folks who are wondering, how do you come into compliance, reach out to Patrick or anyone else within our labor and employment team. And let's turn to Alyssa, who is here for more about non-competes. Alyssa, you have shared a lot of thoughts about this over the last several months, as there has been quite a lot of volatility in the space nationally. And what's new? Because it seems like we've bubbled up and there's plenty to say again.
Yep. So as Gabe said, I'm here to give you an update on what to expect in the non-compete space. And so let's move to the next slide. As we've previously reported on this webinar, the FTC published a rule last year that was effectively going to ban all non-competes. This would have been a huge change, as you all know, because so many businesses and employers are relying on them to retain key employees and protect trade secrets. So with this rule, which was codified in 16 CFR Part 910 and was published in May of 2024, for the most part, all non-compete clauses were going to be banned. For those of you who have been following along, you may remember that a federal judge in Texas did issue a nationwide injunction against this rule, deeming it to be overbroad and beyond the scope of the FTC's authority. So on the next slide, I outline the latest update regarding this injunction. So now that the FTC is under Republican control, the new chairman, Andrew Ferguson, announced on September 5th that the FTC will not be challenging the injunction, and further went along to agree with the courts that the Biden administration's rule would not be enforceable. So what does this mean for non-competes? On the next slide, I go over what to expect now that the FTC is no longer pursuing the challenge to the injunction, but still has authority to govern non-competes and enforce ones that are not considered fair or legal. So it's not just anything goes now that they've abandoned these efforts to strike all of them down. But as I said, they are continued to be subject to strict oversights. The FTC has authority to do this under Section 5 of the Act because they can investigate any unfair method of competition, and this includes non-competes or restrictive covenants that are considered unjustified, overbroad, or just any way anti-competitive or unfair. So we've also seen many states have their own regulations. There's a few states that even ban them. We've seen bills like this in New York, but as of right now, the mere existence of a restrictive covenant or non-compete clause does not mean that it is per se illegal or automatically unenforceable. Chairman Ferguson went so far to say in this statement that the FTC's withdrawal of the appeal is not to abandon the American workers who are affected by unfair non-competes. And he said that the administration is choosing to protect workers by doing what Congress has instructed the FTC to do, which is patrol the markets for specific anti-competitive conduct that hurts American consumers and workers and take those bad actors to court. So to illustrate that the FTC is still interested in enforcing non-compete clauses that undermine competition or are unfairly imposed on workers, on the next slide, I am highlighting two recent actions from the FTC. The first happened on September 4th, 2025, where the FTC ordered a business that is doing business nationwide to stop enforcing the restrictive covenants that it had presently in place with an estimated 1,800 workers. So this company, Gateway, is considered to be the largest pet cremation business in the country, was told it cannot enforce the non-compete clauses, and it is also required to notify all of its employees that they are no longer subject to those agreements. And then a few days ago, the FTC issued warning letters to several large healthcare employers and healthcare staffing firms, urging them to just do a review of their employment agreements. So these were warning letters, they weren't official actions. The letters emphasized the position that the healthcare industry is especially vital, and the FTC is taking an increased interest in promoting fair competition and employee mobility in this space. So in summary, on the next slide, I have just a few takeaways from this, which is the injunction against the FTC rule, it's going to remain in place. That rule is not going to be it's not going to be enforced. The non-compete clauses in general just remain subject to state regulations and strict oversight, and so they need to be narrowly tailored to the circumstances. So as always, if you have questions or if you're thinking about implementing a non-compete clause, it's really important to reach out because there are such strict oversight and they need to be narrowly tailored. So please reach out if you have any questions.
Alyssa, thank you very much for that thoughtful and concise update. It gives us a good idea as to how the landscape is shifting. And sounds like with the change in federal administration, there's a certain solidity around whether there will or there will not be regulation and enforcement's happening through other avenues. Let's go to the next slide, please. And Kathy, I'm going to quickly walk through a couple thoughts. I'm not going to give a full-fledged presentation on this topic, but if all of you wouldn't mind sticking with us for just a moment more, if Kathy would go to the next slide, please, we'll walk you through what's happening with regard to hospital cybersecurity requirements in New York State. About a year ago, exactly, I came to all of you and shared that there was movement within the New York State Register, essentially calling for enhanced cybersecurity regulation with a data security component for hospitals. And we're now coming up to the enforcement date of October 2nd. And so there's a fair amount of concern, consternation, pick your term of art, around whether, as we move to October 2nd, these changes are ones that hospitals viably can come into compliance with. The rationale for these changes was essentially for New York to have more expansive standards than the federal standards in the space, whether HIPAA or otherwise, that we don't have time to go into right now, but that's the landscape that this was to bolt onto and enhance. But there are questions around how it's going to be paid for, requirements that extend to vendors working with hospitals, and how broadly the data are being defined in terms of what is to be covered by these standards, including certain business arrangements, which could lead to medical research, things that had not previously been carved into some of these protections, reporting requirements, et cetera, that really this is all intended to bring to bear or otherwise to allow for the state to have more information more quickly. So we will be keeping all of you apprised, particularly those of you in the healthcare delivery space, whether hospitals specifically or those otherwise, because there are emanations to this. Certainly there are overlaps or overlays in this kind of material as between our cybersecurity and data privacy practice and our healthcare practice. I, as you all know, sit with a foot in both. And so this is an issue that I'll personally make sure to keep you all apprised on, but I wanted to give you a snapshot around this. And if you happen to be a hospital wondering how to make this work, reach out to me or any of the other bond attorneys that you feel comfortable with, and we can dive more deeply. But with that, we are a bit over our half-hour mark. So let me move to wind up the program by specifically noting, I don't see any questions in the chat, but that's okay. You can always reach out to us through email, by phone. Any of us who presented here wants to be available to you as a resource. I will be back with you in 2 weeks. You'll be with Carrie on the 23rd, and I'll be here on September 30th, our last program, of course, for September, on the last day of September. I very much look forward to that. In the meanwhile, we're just grateful that you've taken the time to be with us as always, and we want to be that continuing resource to you. So reach out with any question you may have. In the meanwhile, have a terrific afternoon and enjoy that formal flip into the fall season.